Thank you. Please be seated. All right, we're here for oral argument in State v. Lucas, which is our case number CR24-0199. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Good morning. May it please the court, my name is Monica Clapper, and I represent the defendant in this case, Victor Lucas. I intend to reserve 5 minutes for rebuttal, and I understand that I am to keep track of that. Two circumstances in this case require reversal of Mr. Lucas's convictions, whether this court considers them separately or in combination. The first is that the trial court refused to conduct oral voir dire of the panel and refused the defense attorney's request to conduct oral voir dire of the panel in violation of Rule 18.5, and the state concedes that that was an error in this case. And the second is that the trial court allowed a biased juror, juror number 5, the one at issue in the briefing, to be seated despite clear expressions of bias in her juror questionnaire. The result
Sorry to interrupt. 18.5F says, upon request, the court must allow the parties sufficient time with other reasonable limitations to conduct a further oral examination of the prospective jurors. What is the scope of that other reasonable limitations provision?
Well, that section has been, or that language has been interpreted in several cases along the way from the Supreme Court and this court to preclude things like questioning that is harassing or questioning that includes confusing hypotheticals, questioning that is otherwise inappropriate. The court can restrict that.
Okay, so if the court thought the hypothetical that counsel wanted to pose to the jury here was confusing, he had the discretion to keep it out.
He would have, yes. There is absolutely no indication at all that the court thought that. The court just flat out denied the defense attorney's request to conduct any voir dire, and the court itself failed to conduct its own oral voir dire, and that too is mandated under Rule 18.5.
The court, I thought, did allow the lawyers to question 2 jurors, right?
Specifically about the juror questionnaires as the court and counsel were rushing through looking at the 41 questionnaires to determine whether there were strikes for cause.
So you're saying the court is required itself to conduct voir dire of the prospective panel?
Absolutely. That is
in 18.5F?
It is. It's at 18.5D. The subsections have been renumbered over time. The court must conduct voir dire orally. And there's good reason for that, as put forth in the working group's report about the implementing the new rules to implement the Supreme Court's abandonment of the peremptory strikes. The second error, well, the combination of these 2 errors results in a biased juror being seated on Mr. Lucas's jury and the jury being otherwise inadequately vetted.
So we take the error and we run it through a standard to see if a new trial is required. Do you agree that standard is set out in Moody?
Oh, absolutely not. That standard, first of all, is set forth in State v. Anderson as structural error. And secondly is set forth in State versus Schoen, which requires the state to prove harmless error beyond a reasonable doubt. The reason that this error is structural error this case is virtually identical to State versus Anderson, where the Supreme Court found an error like this to be structural error and to not be amenable to even a harmless error analysis. In State versus Anderson, the court addressed a situation where there was no oral voir dire allowed. There were jury questionnaires. This was a death penalty case. There were jury questionnaires. The court did not conduct or allow the parties to conduct oral voir dire. So there's no oral voir dire record. And three jurors actually, were presumably, apparently, improperly excluded from the jury pool. And the court found the two facts together constituted structural error. An error in the mechanics of the trial, the very basics of the trial, one that isn't subject to an analysis that is normally applied to a trial error, like the trial error in the case this court previously addressed. That is subject to harmless error, prejudicial error, waiver, all sorts of things like that. This sort of error, an error in the constitution of the jury itself, is not subject to that sort of analysis. Just like in Anderson, in this case, there was no oral voir dire conducted, no oral voir dire allowed, and a presumably biased juror. So it's parallel to State versus Anderson, and there is no indication, contrary to the state's argument, no indication at all in this court's jurisprudence, the Arizona Supreme Court's jurisprudence, or federal law from which this structural error analysis is taken, that the type of analysis in Anderson is limited only to the facts of Anderson, that being only to a Witherspoon type error, which is an error in the constitution of the jury, in capital sentencing cases.
If it's structural error, then it doesn't matter whether a biased juror made it on or not, right? It's structural.
In a way, it doesn't. The appearance of bias of the juror is sort of part of the structural error analysis to begin with. So there's the lack of voir dire, which maybe alone, if there was no issue regarding any of the jurors, the lack of the voir dire might not itself rise to that level. It's the refusal to allow voir dire plus the error in the constitution of the jury itself. And juror number 5 wasn't the only juror for which there's a problem.
I mean, isn't that gets you back to State v. Moody, which said you have to show two things. The voir dire examination was inadequate, which you're saying it was. I think the state concedes. And as a result, the jury selected was not fair, unbiased, and impartial.
Well, in State versus Moody, there was some voir dire of the jury. That is the difference here. Here, there's none. So in State versus Moody, there's an ability to weigh the bias of the juror at issue, or jurors at issue. There's a way to evaluate it based on the totality of the oral voir dire. So for instance, say the juror in this case who expressed that yes, she did believe the defendant was guilty simply because he was charged. If there had been an oral voir dire and that concept was explored in more depth by the defense attorney and the state and the trial court, and maybe examples were given that would explain to the entire jury panel kind of how the presumption of innocence beyond a reasonable doubt, state's burden, all of that worked, that would give some context, maybe even in certain cases rehabilitate a juror like juror number 5. And that is what Moody goes to. That's the kind of situation.
Does the record indicate that the defendant asked to have that conversation with juror number 5?
Not specifically with juror number 5. No. What the record indicates is, let me take a drink. The trial court had an unreasonable pace for this jury selection. It was unrealistic.
But everyone looked at the questionnaires, and based on the questionnaires, they did individually question jurors 8 and 10, I think.
They did. They missed a lot. And it is because of the unrealistic pace that the court set in this jury selection process. A little over an hour to select 10 people to serve on this jury out of 41, and that includes the analysis of the jury questionnaires. Everybody missed.
I had a hard time understanding how the hypothetical that counsel wanted to pose to the prospective jurors would have, I guess, filtered out this issue with juror 5.
It may have. We don't know if it would have or not. The hypothetical clearly went to issues that this juror had a problem with, that it's the state that has to prove all of the elements of the crime beyond a reasonable doubt, that the defendant need not offer any evidence at all and is presumed innocent until proven guilty. The defense attorney, I think, did a very good job of explaining that this hypothetical starts a conversation about these concepts of law, these basic concepts that are so important in criminal trials, starts that discussion with the potential jurors. And
the juror said, she qualified her answers. On one, she said, I believe if he had a firearm and intent to hurt someone, that is wrong. This is an aggravated assault case. I think that's a higher intent requirement than the state would even have to show in an aggravated assault case. Is an ag assault just an intent to put someone in fear of bodily harm?
Yes,
so I think she's setting forth a standard in that qualification that is higher than what the state would have to prove at trial.
It is not higher. It is different. So the argument that these qualifications and the two, there's another question as well, Your Honor, that goes direct.
She thinks the element is intent to hurt someone, which seems like a higher burden to me than intent to put someone in fear of bodily harm.
It's a different type of aggravated assault than, I wouldn't say that it's a higher burden, but it is a different element, a different way of charging the same assault.
But her explanation to her yes answer doesn't speak to which side she believes has the burden of proof, right?
Exactly. And it doesn't speak to all of the elements of any of the crimes charged. And that goes to, both of the questions that she answered yes to. And I want to point out, and this is important, that immediately prior to these questions, there are statements of these principles of the law that this juror says she understands and can apply, and then right away gets it wrong. Do you believe that he is guilty simply because he's charged? yes. That immediately follows the instruction that is just to the opposite.
I mean, the court, both at the beginning and the end of trial, instructed the jury on who has the burden of proof and what that burden of proof is. Don't we presume that the jury follows those instructions?
Well, in ordinary circumstances, you do. In a case like this, where you have a biased juror from beginning to end, you don't.
I guess what proof do you have that she was biased after she received the initial instructions from the judge on what the burden is and who has it?
Well, I'll tell you, what I can answer is that we would know a whole lot more if the court hadn't erroneously denied and declined any oral voir dire. That is what this court and the Supreme Court looks to in evaluating bias, not the instructions at the beginning and the end of trial.
I guess
But the voir dire.
Let me ask it as a more open question. Do you have any proof that this juror did or said something during trial that after receiving the court's instruction that indicates she remained biased?
There is nothing in the record showing that,
Okay.
and that is not Mr. Lucas's burden. That is not the defense burden. The burden is on the state to show, if this court bypasses the structural error analysis, the burden is on the state to show that there wasn't any prejudice.
Even if there was no objection to this particular juror, I would think normally we would apply fundamental error analysis in which the defendant then would have the burden.
What happens is this circles right back to the fundamental error analysis looks first to the voir dire. There is no voir dire here, and that is the real error, the absence of the voir dire. And the absence of both the court conducting the voir dire and allowing the parties to conduct. And I want to just get out very quickly that this wasn't the only error that occurred because of the absence of voir dire and because of the rushed pace, the unrealistic pace that the trial court wanted to conduct this jury selection in. There was one juror, juror number 20, who was just erroneously stricken from the panel, and the court apologized. But that juror, in theory, was in the number range that that person would have served on the jury. There's another instance, juror number 24, who did serve on the jury, expressed inconsistent statements in her questionnaire about her opinions about firearms. She was overlooked. She was never questioned. She was placed on the jury. And this falls on the trial judge in this case, not on the parties. The parties, you can tell, are doing their very best to keep up with this pace. We're just not able to, again, because it was an unrealistic pace. And I will reserve my last couple of minutes.
Thank you.
Thank you.
May it please the court, Madeline Shoup representing the state. I want to start off by kind of framing the facts of this case again. Ms. Clapper said multiple times that there was no voir dire in this case, and the state disagrees with that characterization. Here, there was voir dire in the sense that the court and parties conducted an incredibly robust and comprehensive written questionnaire that went through kind of all of the major questions, both case-specific and kind of just sussing out generic biases that jurors could come to, that allows this court and the parties to evaluate each juror that sat on the panel and to evaluate whether or not they came and sat on this panel with any potential biases.
So can a jury questionnaire replace oral voir dire?
No, Your Honor. And that's where the state's concession of error comes in, that the state concedes that the court erred to the extent that it failed to conduct an oral voir dire of the whole panel, both on request of defense counsel and on its own. Rule 18.5D states that the court must conduct voir dire orally, and even though the 2022 rule changes encourage courts to conduct a case-specific written questionnaire, that does not replace the court's responsibility to conduct an oral voir dire. However, in this case, that kind of didn't really affect it very much.
Is that issue different than allowing the hypothetical?
No, Your Honor, it's kind of tied into it, especially because Rule 18.5 F also states that the court must allow the parties sufficient time to conduct further oral examination. So to go to your earlier question about whether that hypothetical could have been...
Yeah, what if he just said, I don't like your hypothetical, it's confusing and quirky, and I think it's gonna fall flat?
I think that would be a very different case, and I think that that the court had the power and the discretion to deny that hypothetical, especially because I think that hypothetical was kind of framed as a trick hypothetical and wouldn't have necessarily been...
What if I think the hypothetical is confusing and quirky and probably would have fallen flat? What impact does that have on my review?
I think the state would like this court to publish this case and to explain that despite the rule changes that courts should conduct written questionnaires, that trial courts still need to bring in the jurors at some point for oral questioning. So there's kind of like two ways to view this error. First, in the court's failure to fulfill its own duty to question the juror panels, but then also talking about defense counsel's specific question that he wished to ask to the panel. So I think...
What does the record show about why the trial judge didn't allow the hypothetical?
Yeah, and that's where the state's concern comes in through, is that the court stated that it denied oral voir dire because it thought that with the rule changes that we don't do this anymore. That the court thought that, this is just not the way that we do voir dire anymore when we have a questionnaire. So that's where the state's concern with this type of situation is. And going to that hypothetical, had the court stated, as you said, that this hypothetical is excessive and not helpful, I think that goes more towards the figuring out whether the panel itself was biased and evaluating whether or not the questionnaire kind of enables this court to, as in Moody, evaluate whether or not the defendant has proved prejudice in this case.
Because defense counsel was given a chance to do an offer of proof of what he would ask, and the only thing he came up with was the hypothetical, right?
Correct. And
I think the prosecutor suggested he should do the offer of proof, and then he had this one thing.
He did, yeah. So the state suggested that the defense counsel give an offer of proof, and this is the only question that defense counsel proposed. So that's kind of the state's kind of dual argument as to why there was no error or prejudice in this case. First, that there was no juror that indicated that he or she would be unfair or unbiased. And secondly, that defense counsel and Mr. Lucas's counsel on appeal no one's highlighted a question that was not covered in the questionnaire that could have been asked to this panel in order to discover some kind of bias or prejudice. I want to start talking about Juror 5.
Juror 5, and don't the answers that Juror 5 gave indicate a miscommunication or misunderstanding?
Correct, yeah. So Juror 5's responses, specifically to follow-up to question 35, I believe if he had a firearm and had the intent to hurt someone, that is wrong. And I believe if he was intending to hurt someone, that could be considered guilty. So to answer Judge Catlett's question to Ms. Clapper as well, that this is he's setting a higher burden of proof than the state needs to show, and is actually saying not that she is willing to convict Mr. Lucas purely because he's been charged by a crime, but that she is affirmatively stating that she's willing to look at the facts and assess whether or not the state has proved this case beyond a reasonable doubt. When we look at other jurors
but the answers don't indicate if she understands who has the burden of proof.
I think that her answers indicate that she doesn't understand the difference between a charge and conviction. Both questions 35 and 39, question 35 kind of explain the state's burden of proof, but then the actual question was, do you believe that Mr. Lucas has been charged with the crime and that he must have done something wrong just because he was charged? So I think that Juror 5's responses kind of indicate more so that she doesn't quite understand the differences between charging and conviction, which was not explained in the questionnaire, but was explained much later or immediately to the jury panel, both in the court's instructions to the jurors before and after the case, and then in both parties' opening and closing statements.
What do we do with State v. Anderson?
I don't think State v. Anderson is controlling here. It's a very different type of error in jury selection and is narrowly related to Witherspoon errors, where the court is removing all jurors that express any sort of disagreement with the death penalty. In that type of voir dire error, the error itself necessarily creates a biased jury because we're removing certain jurors that hold certain prejudices. Whereas here, the error is kind of removing a procedural mechanism that could have potentially uncovered bias, but because here we have that written questionnaire, we can look at the jurors' responses and kind of evaluate on our own whether or not there was some form of error. So to use the language of Perez-Gutierrez, this is more of a trial error as opposed to structural error, because the facts of this case allow this court to quantitatively assess the prejudice caused by the errors and to determine whether the error harmed the defendant. I want to talk to...
It's kind of a unique little area, because normally when we have error, we then look for an objection. If there was an objection, it's harmless error. If there wasn't, it's fundamental error. Here we have State v. Moody, which is kind of its own little standard for this particular problem. Is that Moody's the standard we should apply here?
Yes, Moody is the standard.
Both alleged problems, both the panel overall and this individual juror?
So as to the first issue of the court's failure to conduct oral voir dire, Moody does control both. I agree it is kind of a weird standard that's not similar to other criminal cases where, as part of the defendant's burden of showing error, the defendant must show not only that there was some kind of error here, that the court failed to conduct oral voir dire, but then also that the error created impaneled jurors that were unable to render a fair and impartial verdict.
Because under Moody, the defendant has the burden, right?
Correct.
Even if there's an objection.
Correct.
Yeah.
Correct. And as to the second issue of the failure to remove Juror 5, this court reviews that for fundamental error, because when Juror 5 kind of came up in that consideration of voir dire, which I'll say now, I disagree with Ms. Clapper's characterization of the voir dire process. I think it was really robust. I mean, we have an hour-long voir dire process for an aggravated assault trial. The trial itself only lasted 2 days, and so this actually is an example where we have the court and parties who are coming into this kind of process of vetting jurors with notes on each of the specific jurors based on their questionnaires. They're going through each juror individually and looking at their responses and evaluating whether or not they come with bias and prejudice.
Yeah, what would the court have asked if it itself conducted voir dire of the jury panel?
So that's kind of the interesting thing in looking at errors. I think that this is a case where oral voir dire feels like it's kind of repetitive or unnecessary because we have such a robust written questionnaire that kind of covers all those bases. But I think in these types of cases, the Supreme Court is signaling that even when there's a case-specific written questionnaire, there still needs to be some component of voir dire, and I think in this case, had the court simply brought in the jury panel, asked the jurors if they had any further questions, double-check that they don't recognize any of the court or parties, and then just kind of affirm that they're willing to follow the court's instructions.
And the court did ask questions of 2 jurors, right?
Correct. So strictly speaking, there was oral voir dire in the sense that...
I mean, 18F says you have to let the lawyers do it, so I think that's different.
I agree.
But B says the court must conduct voir dire orally, and during that examination, the court may call to the jury box a number of prospective jurors equal to the number to serve plus the number of alternates. So I'm not sure calling 2 of them based on problems with the questionnaire is not consistent with 18.5D.
There's definitely an argument that it could be consistent. I think the state is more just concerned about a slightly factually different case than the one before us, where when we have the next case where a judge decides that they don't need to do oral voir dire could have a questionnaire that is less comprehensive.
So the state's concession is under 18.5D and F?
Correct. Correct. And kind of the state reads those 2 rules together and to say that, as part of the court's responsibility to conduct oral voir dire, that at some point means bringing in the whole panel, and that the questioning of those 2 jurors does not satisfy that responsibility. And
it's sometimes the case that during voir dire, answers that one particular juror gives may trigger thoughts or answers that among the rest of the jury panel, which will cause them to raise their hand, whereas they may not have raised their hand initially. In other words, the written questionnaire doesn't take the place of the voir dire of the panel as a whole, right?
Precisely. The state's concerned about kind of that exact hypothetical that there's just so much that could happen in oral voir dire that we don't want to remove from jury trials in Arizona. We've kind of already, reinvented the jury trial with removing of preemptory strikes. We don't need to change that anymore by completely eliminating oral voir dire. But in a case like this, the oral voir dire doesn't need to be as kind of long or comprehensive when we have written questionnaires that are able to kind of go through. And I think even with this case specifically, the court and parties agreed with every single juror that sat on the panel. When that juror came up for consideration, the state, defense counsel, and the court all stated that those jurors raised no concerns. And that includes juror 5. Juror 5 was numbered prospective juror number 17. And when juror 17 came up, the court, the state, and defense counsel all agreed that juror 5's responses raised no questions.
So back to Moody, how does fundamental error then work into Moody? If there is an objection, we apply Moody. If there is not, we apply fundamental error?
I think Moody applies...
It's like a very good framework for the state.
The fundamental error only relates to specifically the removal of juror 5, and when we kind of consider that issue in isolation. But in looking at kind of the error as a whole, Moody controls and saying that, and it cites Walden for that proposition that this court is not going to find that the trial court abused its discretion unless there's a finding that the seated jury was unable to render a fair and impartial verdict.
But you're not suggesting we ignore juror number 5 for purposes of that first issue?
I think you can consider juror number 5 for purposes of that issue. That's the juror that Ms. Clapper has raised as a juror who potentially has any bias. It's just the state's argument is that juror 5 does not indicate that there was bias. Because her statements, as we've said before, indicate that she's willing to look at the facts as presented by the state and defense counsel and evaluate whether or not the state has proved its burden beyond a reasonable doubt. When we look, too, at some of the jurors that were removed for cause, there were actually 5 or 6 jurors that were removed for the same questions that juror 5 responded to. And when we look at those jurors' responses to the follow-up questions, we can kind of compare and contrast what the court and parties were looking at. So, for instance, juror number 25, who was removed, stated, "I think if he was charged for using or threatening someone with a deadly weapon, he is guilty." So when we look at that statement compared to the statement that juror 5 made, I think it's a little bit easier to kind of see in comparison what the court was looking at when evaluating whether or not juror 5 herself was unable to render a fair and impartial verdict. And then even if...
Why? Because she said intent, she included an intent component to her answer?
I think more so because her statement is an if-then statement of if the state has proved it's the elements, then I'm willing to find her guilty.
Well, she didn't say if the state has proved. She said if this happened. She didn't indicate which side she thought had the burden of proving that.
Correct. Because she did not state that correctly, that specifically, because she's not an attorney and wouldn't necessarily know that to use those kind of like trigger words. But I think in her own way, she's kind of more communicating that I'm willing to find him guilty if these things are shown. And State v. Riley, which is primarily a case the state cites for the second issue of the removal of juror 5. Sorry to keep kind of jumping back between the two issues. But in State v. Riley, they specifically discuss a juror whose responses indicated kind of a confusion on the law. And then State v. Riley explained that when that happens, that juror can still sit because the court's instructions and defense counsel in the state's kind of explanation of the burden of proof is able to kind of mitigate that confusion and kind of clarify that for the juror. Unless the court has any further questions.
Sorry, I know you're
No, you're so good.
Parachuting in to stop you. What sorts of things would the defendant need to have or prove to meet the Moody standard? Additional comments made by the juror during trial, or?
I think as far as juror 5, just for that statement to be more indicative of someone who is going to be biased or prejudiced. So I think that the defense counsel can show error under Moody by 2 ways, by either pointing out a specific juror that was unfair and biased, or pointing out that the error itself kind of created prejudice, kind of like the error in Anderson. Or third, if defense counsel points out a question that defense counsel could have asked that would have uncovered further bias. And I think here that's really important here because there's kind of nothing left to be desired from this questionnaire that we don't know about these jurors. And having not raised something like that, this court can look at all the responses and see whether or not the jury panel itself was biased. So unless the court has any further questions, I just want to conclude by asking this court to find that the error was harmless and affirm Lucas's convictions and sentences. Thank you.
I know I have a very short time, so I want to just address a few things. The question about what would have been the point of the oral voir dire, what could have been elicited during that voir dire. In addition to what Judge Kiley said, the working group that put together these rules after the elimination of the peremptory strike specifically pointed several times to the fact that we can't expect jurors to self-assess their own biases and self-reveal in these juror questionnaires. They have to be given some context. There has to be some discussion so that jurors can take the time to reflect on whether they really do have some sort of a bias, whether they really are confused, despite what they put in the jury questionnaires. The average time, and I point this out in the brief, to answer these 80-some questions, 15.4 minutes. That does not reveal a whole lot of self-reflection. That is what was supposed to be done by the oral voir dire. I urge this court to...
What does the record show about where the questionnaire was filled out? Was it done at the courthouse, or was it sent to the prospective jurors before they even showed up?
It was at the courthouse in the morning. The attorneys were then given the packets in the early afternoon, and they were not given enough time to go through those questionnaires as the state would like you to believe. From the get-go, the very first thing that happens is the attorneys say, "Judge, we haven't been able to confer on these. Can you give us a little more time?" The state asked for more time on behalf of both parties, and the judge said, "No, we're moving on." So we can't pretend that the parties and the court saw the responses from juror number 5 and just decided that they were of no concern. That would be ridiculous. We cannot do that. Everybody missed them. Of course they missed them. They're very similar to other jury questionnaires that the parties did. Those answers are similar to other juror questionnaires where the juror was struck. So thinking that this was some sort of a strategic decision is just very unsupported by the record. Everybody missed it. Thank you very much.
Thank you, counsel. Thank you for your argument and briefing in the case. We will take the matter under advisement and get you a decision in due course.